Court's coming to order. All rise, please. You may be seated.
Murders.
May it please the court.
Yes, sir.
Your Honor, John Murdaugh's Deputy Attorney General Don Zelinka and Carson Burney here on behalf of the Attorney General's office. This is the State of South Carolina versus Curtis Edward Smith, State Grand Jury Indictment 2022 GS 47-10. As Your Honor knows, this was a 12-count indictment. Judge, procedurally, he appeared before Your Honor on June 28th of 2022 for his initial bond setting. Your Honor gave the defendant $250,000 bond, house arrest, GPS monitoring, several other standard conditions for the state grand jury. On August 11th of 2022, on state's motion, Mr. Waters appeared before Your Honor and asked that Your Honor revoke Mr. Smith's bond. At that time, Your Honor did revoke his bond. Your Honor, we are here today on behalf of his attorneys, Ms. Amy Zimmercheck and Jared Couchette, who have a motion to reinstate the bond.
Further defense?
Thank you, Your Honor. I'll begin briefly. We did file a motion to reinstate bond. Mr. Smith has been in jail since the revocation hearing. As you can see, physically, he has changed a lot. Probably since the last time you were in front of him, he's gained quite a bit of weight. He's had a lot of medical issues, Your Honor, and that we need to address. Additionally, Your Honor, he has been fully cooperative with the Attorney General's office in these matters. And then I believe the rest of the information Mr. Bichette has about how many days he's been in.
Yeah, Your Honor, I would just point out, since the time of the revocation, it's been 235 days by my count that Mr. Smith has been incarcerated on these charges. As Ms. Zimmercheck said, he's been fully cooperative with the government. I don't think there's really any dispute about that, and we think that that the lesson learned, for lack of a better term, that arose out of the revocation is not one that's need to be learned again. Eddie is fully committed to abiding by the letter of this court's order going forward as we litigate these issues, and we just asked the court to reinstitute the bond that it did back in June of last year.
And Your Honor, we are prepared to say some other things if Your Honor would like to hear.
Yes, sir.
May it please the court. Judge, we wouldn't be back here and most respectfully asking you to consider that just for no reason. When I got involved in this case last year, and Mr. Zelinka and I reached out to his attorneys, Mr. Bichette and Ms. Zimmercheck, and as a result of that, Mr. Zelinka and I both had several meetings with Mr. Smith before the trial. During the trial, I met with him in anticipation of his potential testimony in the case against Richard Alexander Murdaugh. Judge, he cooperated with both Mr. Zelinka and myself. Numerous interviews, numerous hours. No deal has been reached with Mr. Smith. I asked him, and Mr. Zelinka did, for his cooperation through his attorneys and through Mr. Smith. He agreed to do that. He was prepared to do that, I believe. And if he had been called upon, again, the decision was made not to call him, that there was an issue whether or not we may or may not need to call him in reply. The decision was made not to. But he fully cooperated with us throughout this process and was willing to testify if called upon. Based upon my years of experience, I think he would have testified truthfully. I did tell them, again, I didn't promise them anything except that I would take his cooperation into consideration and bring that forward to the court. After the trial was over, his attorneys approached us and said, would you be willing to consider reinstating his bond? I said I had to check, and I wouldn't be here before you asking you to put yourself in a position if I hadn't checked. I wouldn't do that to the court. Judge, we did check with all the authorities and Attorney General's office. I've checked with law enforcement. They are aware of this proceeding. Lack of a better word, they trust our judgment. He was willing to cooperate, and I feel it's the right thing to do to ask Your Honor, respectfully ask Your Honor. And obviously, Your Honor, in revoking his bond, did the right thing. There's no question about that, and I am certainly not questioning that. Since that time, in my involvement with Mr. Zelenka, he has cooperated completely, and we are asking Your Honor to take that into consideration. And the state is asking Your Honor, respectfully, if you would reinstate his bond with the exact same conditions: house arrest, GPS, monitoring, drug tests. If Your Honor feels it's appropriate, if you don't, Your Honor, no one respects you more than I do. But I'm just trying to put on the record and fulfill my obligation. I believe that I did promise in their exchange for their cooperation, I would tell the court, I think I'm doing what I promised to do. Judge, I do want to highlight one thing. His prior record was a receiving stolen good back in 1985 and a simple assault and battery in 2002. The only other involvement he has had in their pending charges are when he got involved with Richard Alexander Murdaugh. Other than that, he has no prior record. Your Honor, Mr. Zelenka.
No. We speak with one voice on this, Your Honor.
All right, Senator check.
Thank you, Your Honor. We absolutely appreciate the consideration and the consent of the Attorney General's office. I can't tell you how many hours of emails and telephone calls and meetings with Mr. Smith that I have had. He understands.
Smith send you emails?
Yes, Your Honor, from the jail. Quite honestly, it saves me the time going down there, so I love it. But Your Honor, the focus, I can tell you, the focus of our conversations have been how important it is that he understands exactly what this court is directing him to do. And Your Honor, his bondsman is here in attendance and prepared to, he's sitting here.
Where's that bondsman? What's your name, sir?
Benjamin Rock, Benji's bail bonding.
Benji Bill, sorry.
Benji's bail bonding, I think it was Benjamin Rock.
Benjamin Ross, Benji's bail bond. And why are you here?
I was contacted that they were going to look at reinstating his bond, and I'm just here to pretty much sign on it, be that the court see fit.
He was in agreement, Your Honor, to remain on the bond if it were to be reinstated.
Is that right, Mr. Ross?
Yes, sir.
All right, thank you.
And Mr. Smith understands the parameters of the home detention and the GPS monitoring, Your Honor, as well as all of the other conditions, no guns, anything else that the court felt like it had put in its order, and of course anything else that the court may need to add. But Your Honor, at this point, we would just respectfully ask that you reinstate his bond.
Mr. Boucher, anything else?
Nothing further, Your Honor.
Mr. Smith, what do you have to say?
Yes, Your Honor. I understand the significance of these cases. It's tied in with Alex Murdaugh, and I totally understand the importance of the letter of my bond. And when I get on my property, ain't nobody gonna drag me off. Nowhere. Thank you.
How many pounds have you gained?
Ma'am?
How
Sir?
many pounds have you gained?
About 55. My sugar's off the chart, blood pressure's off the chart, so I mean, and I got titanium rods and screws in my back, and I have not been able to get any medical treatment for my pain for 8 months.
And all of that caused you to gain weight, or?
Yes, sir. Not be able to get any exercise. I'm used to working in the garden. I work all day. I enjoy work, and I haven't been able to do anything.
Anything further?
Nothing further from the defense?
No, sir, thank you.
So you're asking me to reinstate the bond with the same conditions
Yes, Your Honor.
and the bond that was previously ordered was a surety bond of the sum of $250,000, no 10% allowed. Defendant not to leave the state of South Carolina without permission of the court. At the request of the state and/or at his own expense, the defendant shall be subjected to drug tests and must appear at whatever facility designated by the state for drug testing. Shall have no contact with any co-defendant or witnesses, including victims or victims' families, if any. He does not have a current passport. His passport is expired. Shall not sell and encumber any property while on bond without permission of the court. Must appear at all scheduled hearings and the trial. Must keep the clerk of the court, clerk of the state grand jury advised of his current home address and phone numbers so that any notices can be sent if necessary. Mr. Smith understands that any future violations of any federal, state, or local laws will be considered a violation of the bond and grounds for revoking the bond. And understands that he has a right to be present at the trial and it's his responsibility to maintain contact with his lawyers and the court such that he will be present whenever called upon to be present. And that the bond must be a sufficient surety in a matter prescribed or approved by the clerk of the court of the grand jury. He must waive extradition, and he is placed on house arrest without exception, except to work, church, schools, attorney, or medical appointments. And I think the last time, Mr. Smith, as I understand it, you took that word work. You interpreted that to mean that you could go any place you wanted to go as long as you said you were working.
But,
You ended up going all kinds of places.
yes, Your Honor, I went places I wasn't supposed to go without notifying anybody, yes, sir.
So what kind of work do you consider yourself to be doing?
I'm a truck driver, diesel mechanic, working logging woods, I haul chips from the paper mills, from the power plants to the cement plants. It's the same route every day.
So any work related travel must be approved by the court after notice through your lawyer and the state.
Yes, Your Honor.
So that any
That means you can't work
direction of
this
travel will be
You can't work this week.
included in your
Talk about
GPS monitoring so that everyone will know where you're going. And you must pay for GPS monitoring at your own expense, which must be connected to the device upon your release from jail. And you cannot possess any firearms. And you understand, if this bond is reinstated, Mr. Smith, there will be a strict compliance with it.
Yes, Your Honor.
No deviation, no leniency, no latitude in any way.
Yes, Your Honor. Totally understand.
Anything else?
No, Your Honor, we'll get you that work route this week, and we'll get it to the Attorney General's office as well.
Two things. First, the court will order the bond to be reinstated upon the terms as I just stated, which are the same terms as before. Then secondly, concerning this case and the status of it, we're in the process of scheduling status conferences on all of these cases, except Mr. Harpootlian has indicated his unavailability until the term of the legislature is over. Of course, that did not affect Mr. Smith and some of the other members. So have you all come up with a date that you all want to have the status?
I believe, Your Honor, April 21st is what we replied to your clerk. That worked for, no, worked for both defense attorneys.
Yeah, Your Honor, I replied with whatever date, but we'll be
April 21st.
flexible. I don't recall what I replied to, but I know there were 3 Fridays in a row there.
We'll certainly check with everyone in the office and get back forthwith with Your Honor.
That was the date, right?
And Smith's cases are pending in which counties?
Your Honor, Hampton.
Charleston.
I know that the majority of the cases that were revoked for bond were state grand jury cases, and then he has the additional,
The venue is in Hampton County.
right.
So that hearing will be set for Hampton County.
And I believe, Your Honor, that an order that you signed says that you have jurisdiction over all of those cases, so.
No, I think the venue's Colleton County, all due respect.
Oh, is it, okay, yeah, Colleton, sorry.
Okay.
Do we have venue in any of those cases for Hampton County?
Isn't that what the order is saying?
Roadside shooting cases, too.
Colleton, yeah,
Roadside shooting cases, too.
in Hampton. Yeah.
Yeah,
'Cause the roadside shooting is in Hampton.
all of the state grand jury are in Colleton, Your Honor.
And then the roadside shooting are in Hampton, Your Honor.
Which one?
The roadside shooting cases, the charges that he had arise from that are in Hampton County.
This status conference will be scheduled in Hampton County unless otherwise indicated.
Okay.
Yes, sir, Your Honor.
On this case and the others may be someplace else, but Allendale, Orangeburg, Colleton, Beaufort, we'll decide.
Yes, sir.
But they're all in the 14th Circuit, so the venue for most of them are 14th Circuit. But the next hearing will be in Hampton.
Yes, sir.
And Your Honor, just
And
one,
that's changed by the court because I'm presiding in Richmond that week.
one thing, I know that the court may or may not be able to do anything with this, but we are certainly advising Mr. Smith not to speak with the press, and we would ask that they not descend on his house. I know that the court can't order because we have First Amendment, but we just wanted to make sure that we put that on the record as well.
Yeah, the press might be kind of hard to identify sometimes.
Yes, sir.
We'll see how that goes. But you can make an announcement to whoever you like.
Thank you, Your Honor.
Very good. Thank you. Good luck, Mr. Smith.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
All right, we're outside the Richland County Courthouse here in Columbia, South Carolina with Jarrett Bichette, one of Curtis Eddie Smith's attorneys. Smith's bond was just reinstated by South Carolina Circuit Court Judge Clifton Newman. Jarrett, was this a surprise?
No, it wasn't a surprise. We had hoped this would be the case. I think the state was pretty much in agreement with it. Obviously, it had to be approved by the judge, and so that always makes you somewhat nervous. But I think given what was undisputed at this point and the state's consent that it was appropriate to reinstitute his bond, we were optimistic and hopeful that was what was going to happen.
Well, it was actually more than consent. The state arguing very passionately that Curtis Eddie Smith had cooperated completely. They said on numerous occasions that he sat with them during the trial of Alex Murdaugh down in Walterboro. Let me ask you this question. Obviously, a lot of this is matters involving the grand jury, but tell us a little bit, to the extent you can, about that cooperation.
Well, again, he is testified really from prior to the start of the trial as to what he knew, and he's provided that information to law enforcement. Like I said, I think that's agreed to at this point, stipulated to. So, other than getting into the specifics that we don't want to do at this point, but I think suffice it to say that he has provided everything he knows, and what he knows in no way, shape, or form implicated him in those two tragic deaths down in Colleton County. And so, obviously, during the course of this saga that we've had, there's been innuendos and implications that maybe he did or didn't, or what his respective position would be. But now that it's all finished and that all the evidence has come out and that process has played itself out, neither the state, who investigated this for over a year, tried a case for over 6 weeks, nor the defense team, nor Mr. Murdaugh himself, upon taking the stand, in any way, shape, or form implicated Mr. Smith in any of those horrific events. So that's important to note. And he, to the extent he did know anything that could have been useful, he provided that. And the state ultimately chose not to call him. Most likely because he didn't know anything that was that relevant to what they were trying to achieve, and obviously that's a decision for them to make based on their own case strategy.
Were you surprised he wasn't called?
No. Again, even though a lot of the surrounding events came into the trial, it was ultimately a murder trial, and Mr. Smith had no knowledge about that, was not involved in it in any way, shape, or form. So, no, I really wasn't surprised.
Jared, I got to ask you one question about this. We've heard a lot from Curtis Eddie and from you guys on his behalf about how he wants to tell his story, and he feels like his story needs to be told. Yet in court today, your colleague Amy Zimmercheck requested specifically that the press stay away from him. Mm-hmm. I guess I got to ask you, which is it?
Well, good. We're standing here at the Richland County Courthouse. This is the avenue where a defendant's story gets told. This is where you have the opportunity, as we've seen, for all the evidence to come out, and in the proper context and in the proper arena for a defendant to tell them their story. Now, again, I think Ms. Zimmercheck's reference to providing him some space was simply because you've seen his health. Obviously, he's a private man. Prior to all of this, he was just an everyday working guy living outside Walterboro, and so the request to leave him be was more of, to provide him a little bit of just respect and quiet at his home, more so than it was trying to not want to speak or not want to have his story out there, that kind of thing.
Let me ask you this. Obviously, there's some cases coming up involving your client, so he'll have a chance at some point to address the charges against him, and perhaps in that context, maybe a little bit of what he has to say about Alex Murdaugh.
Well, again, if he's called as a witness on any trial related to co-defendants, then we anticipate that he will testify if he's called to. Again, it depends specifically on which defendant and which allegations and that kind of thing. But we'll just have to see what happens and what the state wants to do.
Appreciate it. Jared, thanks for taking the time. We will look forward to seeing you as these cases move forward.
Absolutely. Thank you.